The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and its honorable court.
Good morning. Mr. Howard, you may proceed.
Thank you, Your Honor, and this is my first time doing a virtual argument. I just want to make sure, sir, if I may, that everyone can hear me.
Yes, it's very clear audio and video.
Thank you, sir. This is a matter, my name is Josh Howard from Gaiman, Howard, and Zazatarsky in Raleigh, North Carolina, and I represent Trevor Soloff in this matter, where our goal is for you to vacate and remand the sentence. We believe the sentence was both procedurally and substantively unreasonable, but I also recognize that the court may be very interested as to why you could hear this matter in the first place. There was an appellate waiver in his plea agreement, and so if I may, I would speak to that first. Ultimately, our argument, Your Honor, is that the district court did not handle the plea hearing, and as a result, it came to be that the district court never actually accepted the plea agreement formally or properly, as we believe the law mandates and should mandate. Ultimately, that creates both harm for Mr. Soloff, but also the opportunity for this court then to review the procedural and substantive reasonableness of his sentence.
Excuse me, Diana Moss. I just want to be sure you're not making any claim that that your client didn't agree to the agreement.
We recognize that he voluntarily and knowingly entered the plea agreement, and we're not seeking to withdraw the plea.
Well, if that's the case, and we should do what you wish, but not find it substantively or procedurally unreasonable, but just find this one flaw, you would send it back, and the district court presumably would expressly adopt the plea agreement. So is there a purpose in doing that?
We believe there are arguments that the district court did not, which goes to our second and third arguments, Your Honor. The district court did not pay enough attention to. It's basically the substantive and procedural reasonableness of the sentence. We would like to give him a second chance to get that right.
Right, I understand that, and that's part of your argument here. But if we should conclude that the sentence was substantively and procedurally reasonable, but that the contention you make with respect to the judge directly and expressly adopting the plea agreement has merit, so we send it back just for that reason, the only remedy would be for the district court to expressly adopt the plea agreement. So what purpose would that have?
Your Honor, we would think that if you send it back, he would have to engage in re-sentencing defendant Soloff.
Okay.
Can I just follow up on that, counsel? Because this may be the same question, in which case I apologize. So if you just assume for a moment, hypothetically, I thought it was pretty ambiguous as to whether or not the district court actually accepted this plea or not. The premise of your brief seems to be that the remedy for that would be that we would sort of declare this plea agreement non-binding, non-enforceable, so that the waiver would no longer bind your client. And maybe this is the same question Judge Motz is asking. If we thought it were ambiguous, why wouldn't we send it back and let the district court say one way or another whether it is accepting or rejecting the plea agreement?
We believe sending it back includes both as part and parcel, whether or not he's accepting the plea agreement, and then re-sentencing the defendant on the substantive and procedural merits.
Well, but the problem with that answer is that in answer to my first question, you said you made no claim that your client didn't enter a valid plea agreement. That isn't your claim at all. So if you've conceded that he entered into a valid plea agreement, I don't see why the district court would resentence.
Your Honor, I need to be clear about that. We believe that he knowingly and voluntarily entered the plea agreement. It's important for proper. And as a result,
Mr. Howard, you need to repeat what you just said. Your words were gobbled for that about 5 seconds. Go ahead.
I'm sorry, Your Honor. I want to be clear that we recognize that he knowingly and voluntarily attempted to enter a plea agreement, but that the district court never properly accepted it. And as such, he could be stuck in an asymmetrical scenario where the government has the benefits of the plea and he has none of the benefits that ran towards him. And as such, if it were to go back to the district court, we believe that he would then have to re-sentence him on the issues that we've raised as to procedural and substantive reasonableness.
But counsel, I don't think you quite followed Judge Mott's scenario to the question. The question is that if the substantive claims you make, procedural and substantive due process violations, if we resolve them saying that no, there were none, the question is, if it went back for remand, what could the district court do other than just reject or formally accept the plea agreement, since you have made no claim that there was any invalidity in the plea? That's the simple question. What could it do more? I know what you wanted to do, but are you saying you had the whole panoply, including the right to withdraw the plea if we send it back for that narrow purpose? Do you have a right to withdraw? Let's take that question.
Your Honor, I don't know that we do after the Rule 11 colloquy with the magistrate judge in this matter to withdraw it. But it's just not been accepted by the district court, which is what empowers your court to review the substance and procedural reasonableness arguments.
Absolutely, and that window being open, if we dispose of it, and you hope not, unfavorable to your client, isn't the window closed to all respects other than just to formally accept the plea?
Your Honor, we believe that if the court has not accepted the plea formally, then it needs to re-sentence the defendant in full.
All right. Go ahead, you may proceed.
I'm sorry, because I am confused. Sorry, it's Judge Harris again. So what you're saying, if I understand right, is that right now the window is open. The waiver is not operative, so we could review this sentence. Is that, but if we were to affirm the sentence, we should still send it back and let the district court, and the district court would then either accept or reject the plea and also resentence?
I think the window
is. That right?
I'm so sorry. The virtual thing, part of it, there was a delay there. I did not mean to interrupt.
Oh, no, I was done.
We believe the window is open for you because of the frailties of the plea agreement not being accepted by the district court. We believe the window is open for you to examine the procedural and substantive reasonableness of the sentence. And as such, if you find errors there, as we hope you will, and we believe there are, then we would have to do more than one thing. We would have to re-sentence for off the full and pay attention to the argument that we feel we're not paying attention to under Blue and Ross.
Counsel, it's Diana Motz again. I guess I don't understand what the basis would be for such a procedure. For example, if we find a defect in a sentence that would require a court to look at the entire sentence, in other words, there are challenges to other parts of the sentence, we send it back. And the district court often will have the authority to look at the whole sentence. But you don't claim any defect to the other parts of the sentence except for this one. I mean, if you had said that I didn't enter the sentence and he got the wrong, he got the wrong guideline range. But you don't say that. So what basis would we have? Your man has already said that he agrees with the sentence, the underlying sentence that was given. I just don't see what we could do for you.
Your Honor, I'm not sure that I'm totally following your question. We don't agree with the sentence. We believe the judge paid too little attention to a number of mitigating factors.
But your man agreed to it back in the day. You told me that was the first thing out of your mouth, that you didn't challenge anything but the lack of the district court to adopt the plea agreement formally.
I am sorry if I miscommunicated that. We don't deny his guilt or his guilty plea, and we don't seek to withdraw that.
Or that he signed a plea agreement.
He signed a plea agreement, which the court never accepted, which empowers you to examine the reasonableness, both procedurally and substantively, of the sentence. And we would hope that it would go back to the court for resentencing based on your examination of the procedural realities.
Well, Mr. Hall, let's put it this way. Do you agree that in this posture as the appellant, you were obliged to raise all questions about infirmities of the sentence now?
Yes, Your Honor, and I believe we did.
No, I'm not right. You did. So if we resolve those in a way that's unfavorable to you, how do you get another bite at the apple for other issues of sentencing not raised?
Well, that's a fair question, and we believe that you have the power, because there's the threshold issue in this whole case. Could it be just the appeal, the whole appeal be dismissed because of the appellate waiver? Well, that's in the plea agreement that we believe was never accepted by the district court. Your court has the ability to recognize it was not accepted by the district court and then examine the procedural and substantive reasons. And I'm terribly afraid I've not answered your question, but we process.
Okay. All right. You want to, unless there are other questions on this, you may want to get to some of your arguments for substantive and procedural unreasonableness.
Thank you, Your Honor. As to procedural unreasonableness, we think they're manifest. Ultimately, this was the defendant in the most difficult kind of case of child pornography, where he engaged in phenomenal and remarkable act of rehabilitation, and they were elaborated at sentencing. He had basically charges of left on bail until he was indicted federally.
Counsel, I can't hear you. Okay, I couldn't hear that.
I'm sorry, Your Honor. I'll lean in. I'm sorry if that makes my picture look even worse than I normally am.
No, you look great.
This is a defendant that, while on state bond before the federal charges took over, had really committed his whole life to curing the pathology that was within him. This is not your everyday bank robbery or other case where the motivations are just greed or anger. It's something that can be cured or at least can be rehabilitated. And he had done so much, fully articulated both in the brief, but also in the joint appendix. And the court gave that, we feel, very short shrift to an extent that violates Blue and Ross and other of your decisions that require the district court to make an individualized sentence. And it has to also the enhancement for using a computer further kind of attempt is now just absolutely antiquated. It's not entirely clear responded to that, but the government has noted in their brief that at some point the district judge said, well, some judges in some places were buried out. And that they may be correct, but they may not be correct about whether or not that was the district judge's response. And where it's not clear, we feel that fails the standards of this court for an individualized sentencing analysis. And I see that my time is up, so I'll be glad to answer any questions.
Any questions from the panel?
Thank you.
Thank you, Mr. Howard. We'll hear from the government.
Good morning. May it please the court, Christine Fritz on behalf of the United States. Today, we're asking this panel to dismiss the defendant's appeal in its entirety. From the beginning, this federal prosecution had a negotiated resolution. The relevant terms of the plea agreement were reviewed by counsel, were reviewed by the magistrate judge during the Rule 11. The parties and the court acted in conformity with the plea agreement. And we believe that the record reflects that the court accepted the plea agreement, even if it never made an explicit statement that it had unconditionally done so. If, however, the defendant is correct that there was no plea agreement accepted, we don't believe that the remedy is excising the appellate waiver as the defendant requests. Either we would think that there should be a limited remand for clarification and further proceedings, or alternatively, if the defendant's position is that there is no plea agreement and that he is not bound by the appeal waiver that was explicitly reviewed by the magistrate judge, and he wants to be relieved of that obligation because in his opinion there's no plea agreement, then that should hold true for both parties. Now, we think that the record shows that the court accepted the plea agreement. Yes, when the court signed the plea agreement following the magistrate judge's Rule 11, the court added a condition subsequent saying that its acceptance of the plea agreement was deferred pending review of the PSR. The court reviewed the PSR, and it did not take the steps that Rule 11 outlines to explicitly reject the plea agreement. The PSR recounted the fact that the parties had entered into a plea agreement that negotiated the resolution of this case from up front. It detailed the impact the plea agreement had, and the court, without any objection from either party, adopted the PSR. Beyond that,
What is the, Ms. Fritz, good morning, good to see you.
yes, good morning.
The court said conditionally approved final acceptance is deferred pending receipt of the PSR. And you just told us that the district court accepted the PSR. What language do we have that says that?
That the court accepted the PSR?
Yeah.
At the beginning of the sentencing hearing, the court asked the defendant and defense counsel whether it had received and reviewed the PSR. It also indicated that it was familiar with the PSR, and the court stated that it was adopting the PSR except as to matters disputed in the addendum, and confirmed that there continued to no longer be any matters disputed in the addendum. Beyond that, we also have the statement of reasons that reflects the district court's unconditional acceptance of the PSR.
Can you tell me, when did these various statements take place? I just thought this was a very odd thing to say, that final acceptance is deferred pending receipt of the PSR. So this statement was made before the district court had the PSR, right?
Correct.
Conditionally approved.
Yes.
Okay. And then a month later, what happened then?
And then at some point, obviously, after the Rule 11 and the defendant's guilty plea, the probation office undertakes its review of the PSR, and eventually there's the drafts exchange, and then the court does receive and review it prior to the sentencing hearing. And then I think what we have here are the court statements at the beginning of the sentencing hearing, obviously reflecting that it had received and reviewed the PSR. But I don't think that our argument doesn't rest simply on the references to the court's acceptance of the PSR. We just think that that is a piece of the evidence showing the totality of the circumstances that this was in fact accepted. Beyond that, during the court's sentencing explanation, we have the fact that the court highlighted that the defendant promptly accepted responsibility and pleaded guilty pursuant to a plea agreement. When the court was reviewing with the defendant his appellate rights, the court specifically stated, you signed a plea agreement, and I believe based on the sentence you received, the appeal waiver would apply, but you can present what challenges you believe are appropriate to the appellate court. After the sentencing, the court implemented the restitution order, which references the plea agreement at least 3 times. And as I was reviewing and preparing for this, it occurred to me that I think the restitution order is actually pretty important to whether or not the court accepted this plea agreement, because if you'll notice, the criminal information covered 1 infant victim. And it is black letter law that you cannot award restitution to victims who are not victims of the count of conviction, absent a plea agreement and the defendant's acceptance of that term. Here, we have a restitution order where the court awarded restitution 12 different victims. And we know for a fact only 1 victim is covered in the criminal information. So when you look at all of this together, we think that it is absolutely clear that the district court accepted this plea agreement.
Can I ask a question? It's Judge Harris. So your colleague started by pointing out that the district court wasn't the one who did the Rule 11 colloquy in this case. There were 2 different people, sort of a division of labor. And I will say that that's what troubles me about the case, the possibility. I mean, I agree with you that there's nothing to suggest that the district court rejected this plea agreement, and it seemed to operate consistent with the plea agreement. But I worry that when you have 2 different people, stuff can fall through the cracks, and it's possible the district court just thought, I don't have to accept or reject it, it's already been done. The magistrate did it. And so that's my concern. And when he says, you know, you did enter into a plea agreement in light of your sentence, I believe that you've waived your right to appeal your sentence. The I believe sort of stuck out to me. Like, it's not obvious that he is doing sort of the careful read you would expect to be done in the process of actually accepting the plea agreement. So that's my concern, that there are 2 different people here. And when you bifurcate responsibility that way, there's the possibility that nobody gets around to actually doing the formal acceptance.
In response to that, I'd like to point out that the magistrate judge during the Rule 11 stated that it conditionally approved the plea agreement. And a couple of days actually lapse, after which the district court itself signs the plea agreement. And I would suggest that this indicates obviously that the district court reviewed and signed the plea agreement. There are times when a defendant may be able to argue that an appeal waiver, may be able to successfully argue that an appeal waiver does not apply for whatever reason. And I think that it is prudent for the district court to simply say, I believe that based on this sentence, that this would fall within the scope of the appeal waiver, as opposed to telling the defendant something that when challenges are presented to this court might not hold true. I think that the court's law repeatedly focuses on the totality of circumstances when deciding whether appeal waiver is valid. And when you look at the totality of the circumstances here, we think the plea agreement was accepted and the appeal waiver was valid. It was discussed. It was discussed between the defendant and his counsel beforehand. He represented that he discussed the plea agreement. The magistrate judge reviewed the critical terms of the plea agreement. The magistrate judge read the entire appeal waiver into the record and said, do you understand this? Do you agree to this? And we now have, even on appeal, it would seem to me that the defendant is not trying to get out of the plea agreement. He seems to want the plea agreement, but not want the appeal waiver that was discussed specifically. And our position. Sorry. Oh, yes.
I'm sorry, can I just ask you a question? If just assuming hypothetically, I thought it was ambiguous, what happened here and whether the district court accepted the plea agreement or not. I want to know what you think would follow from that. Because I can imagine one rule might be, look, if it's ambiguous, you should probably just presume he accepted it because he didn't reject it. One rule, or you might say, well, if it's ambiguous, then I guess you can't enforce the agreement, but send it back right now to the district court before you reach the merits and let the district court clarify the ambiguity and say whether or not it's accepting the plea agreement. And then I guess another result might be, well, if it's ambiguous, don't enforce the plea waiver and go ahead and reach the merits.
If the court, I think, I'm assuming based on your hypothetical that you have found that any other statements or conduct by the court still don't resolve your question.
Right.
Okay.
Right.
I think then the appropriate thing at that juncture is to send it back for a limited remand for the district court to clarify, because the parties need to know whether they have an agreement or not. And I think it's very clear that the parties operated under the belief that this is an agreement between the two. Again, this from the beginning was a guilty plea to a criminal information. The parties negotiated the charge and everything else. So if the question is whether a plea agreement that is binding on both parties in all respects exists, I think then the appropriate thing to do, if at that juncture in time you're still left with questions, the appropriate thing to do is to send it back.
Ms. Chris, excuse me. Can I ask you, have you ever seen this in your court before, this conditionally approved? I've never seen this before. Final acceptance is deferred pending receipt of the PSR?
Yes, actually, for the district judge who handled this, for Judge Dever, it is generally his practice to wait until after review of the PSR to formally accept or reject the plea agreement, especially in cases where it is a plea agreement that agrees to dismiss or forego charges.
And then does he do something after that, after he receives the PSR? If this is his usual practice?
I think that normally I think that in most of the cases that I have seen of his early on during the Rule 11 or during the sentencing hearing, which isn't which isn't stated here, that the court does specifically say early on in the proceeding that the defendant did plead guilty pursuant to a plea agreement. So that this idea of the plea agreement is introduced up front. I think that it would be better practice. And in some of the cases that I noted in my Rule 11 or in my 28J letter, it would be better practice for it to be an explicit statement of I am now unconditionally accepting the PSR.
But it's your representation to us that this is his usual practice and he doesn't circle around and make a specific statement. Is that right?
It is my statement that his usual practice is to defer acceptance.
Right. And without circling around at the end to say, I now adopt it.
Honestly, that particular issue hasn't come up frequently for me. This is only the first time I've had a defendant argue that the failure to make an explicit statement of accepting the plea agreement means that the plea agreement is ineffective or executory. I've not had cause to look at that.
I would think the government would be just as interested in knowing whether the plea agreement is actually effective as the defendant.
I would agree with you, and I can assure you that that is being communicated within our office to try to make sure that we avoid this sort of scenario, this sort of argument.
Okay.
But again, for the purpose of this case, we think that all of the court's statements during and after the sentencing hearing, as well as its awarding restitution to victims beyond the count of conviction, all of this shows that the agreement was accepted. And I think also the party's conduct. Oh, yes, Judge Harris?
Yeah, I'm sorry. I just had one question, and I may have been misremembering or have misunderstood the record, so set me straight if I'm wrong. But does the final judgment say that the government is not bringing any additional charges pursuant to the plea agreement the way it normally would?
No, normally the way the judgment is structured, it specifies, like, there's the line where you write in such charges were dismissed by oral
Right.
motion of the government. Because there weren't any charges dismissed, that box wasn't checked.
Okay, so in your view, the judgment is consistent with the plea agreement?
Yes.
Okay.
In our view, it is consistent with the plea agreement. And I would certainly also suggest, Your Honors, that if, for example, we had failed to move for the third point of acceptance of responsibility, or if all of a sudden we decided we wanted to bring related charges, I would submit to you that the defendant would be arguing that this is a binding plea agreement, and we cannot do that. Nor would we, because we believe that this is a binding plea agreement and that its terms are effective on both parties in all respects. And we're simply asking for the benefit of our bargain. The defendant agreed to waive his right to appeal, and we want him to be held to that. If Your Honors would like, I can turn to the sentencing issues very briefly. We think that the district judge provided a very individualized and thoughtful sentencing of this defendant. The defendant's own brief acknowledges, if you look at pages 6 and 7 of the brief, and then also I believe around 12, it goes through some of the statements that the court made that were responsive to the defendant's arguments about military service, no criminal history, the rehabilitation efforts. Also, the court did discuss the number of images, the seriousness of the images. They were heinous. The court specifically said it is difficult to read. So although the court never said the 1,900 images of child pornography and 96 videos of child pornography were a small percentage of your overall collection, we think that that misses the mark. We think that the court responded to the heart of the defendant's argument there, which was an attempt to minimize the scope of the conduct. And the court responded to that. The court responded by saying, this is extremely serious. You have an enormous number of images. There were 57 known victims and countless more whose lives are forever changed by your conduct. Beyond that, the district judge specifically responded to the guidelines policy argument. The way that the defendant framed his argument about, he said that the guidelines were antiquated, and then he immediately goes into talking about how other judges in other districts have chosen to vary on this. And the court responded to that directly. The court said, I understand your argument about other judges varying for various reasons. I don't think that is appropriate here. And he goes on to say, which I think again reinforces the idea that this was a very individualized and thoughtful explanation. The judge goes on to say, each case is unique. Each case is an individual case with an individual judge who has to determine what sentence is sufficient but not greater than necessary for this person in light of all the 3553A factors. And then he went on to explain why he was not going as high as the government requested, nor was he going as low as the defendant requested. Instead, he was imposing a sentence at the bottom of the advisory guideline range.
Ms. Fritz, there's a question about this, and that is the question that Mr. Soloff raised a question concerned that he was suffering from a mental condition that was almost somewhat compulsory, pornographic, those type things, beyond just rehabilitation. But the whole idea that the mitigator was you had a fragile profile person who led him to be wont to this type of behavior. Where did the court address that aspect of it? That's different than rehabilitation. This goes to the mind of the person before that in terms of whether or not it was an impulsive type of behavior based on a problem. Now, I didn't see where in the record that the court addressed that aspect of the argument. Can you tell me where and how, if he did?
I believe around page 113, the court does talk about how in his assessment, based on the defendant's intelligence, that he knew that what he was doing was wrong. So I think that that is an awareness of the wrongfulness of his conduct and his decision to nevertheless engage in this same conduct from 2000 through 2017. This wasn't an aberrant period. The rehabilitation did not start until after he was caught. And the court was convinced that the defendant knew his conduct was wrong.
But he doesn't have to reach the McNaughton rule in terms of not knowing the difference between right and wrong for at this stage to consider a mitigator that he had problems that led to this being of a somewhat impulsive, if not directly compulsive, behavior. That was his argument, and that doesn't seem to be frivolous. I mean, people very intelligent can be under these type of situations with pornographic material and other things like that. But that's a different question, whether or not he would reach the sense of right and wrong. You could know that very well, but still have some compulsion, like a person who may be, for example, not this case, but schizophrenic, for example. They could very well know their behavior, but because of their malady, they want to do those things, and they're asking for that to be considered when you decide what the sentence should be. That's what a mitigator, that's an individualized thing. That's different than somebody who's never been having a problem before, they go to rehabilitation. His argument was before this. This was consistent with his thing that he was dealing with. And then you're right, maybe it was being arrested and convicted, and this led him to rehabilitation, but that doesn't address his anti-charge and where he was, how was that. I don't see where he addressed that. You're right, he certainly did. He said, you're a very smart person. You're intelligent. You knew what you were doing. This is horrible. That's right. But that's why we look at non-frivolous mitigators. And you're right, this case is fraught with all kinds of situations where it was horrible pornographic material, where we don't even want to talk about it. But the question is, I just don't see where the court addressed that. But that's what you said, address that. I understand the response.
If I may add to that, I think that we have a combination, obviously, of the court acknowledging his intelligence and his awareness of it being wrong. I think later on that same page, however, the court does note that there were gaps in his collection of child pornography. You have activity from 2000 to 2002, and he goes through and he acknowledges that there were gaps. So to the extent that I think that although the defendant had engaged in this conduct over a very long period of time, the record reflects that there were gaps, which would run counter to the idea that the child pornography collection was a compulsion that he was unable to manage. And we believe that a 151-month sentence was absolutely procedurally and substantively reasonable. However, we would ask the court not to reach that issue and instead find that the plea agreement was binding on both parties, accepted by the court, and dismiss this appeal pursuant to the plea agreement.
Thank you, Ms. Fritz.
Thank you.
Mr. Howard, you have some time reserved. Mr. Howard? Are you muted, Mr. Howard? You have to unmute yourself. Thank you.
Am I loud and clear now, sir?
Yes.
Yeah, you're good. You're good.
I'm sorry.
Let me ask you this question before you start off. Let me ask this question. It seemed to me, we've said countless times in terms of Fourth Circuit jurisprudence, a plea agreement in terms of enforcement is a contract between the government and the defendant. It's in contract terms. And there's nothing that said that there wasn't a meeting of the minds in any way in this contract, and you don't challenge that. You only challenge what seemed to be that it was not ratified by the court, which means formally accepting it. Well, if that's the case, your argument is, then basically you're saying that the whole thing is off. You can't cherry pick it. That means I get to the provision that says no waiver, that falls away. I get a chance to appeal these things. No, wouldn't it be like what I kind of understood Ms. Fritz was saying with course, she doesn't want this to be the result, but she said if that wins the day, then the whole thing is off. And it works on both sides. That means that your client doesn't have a plea agreement at all now because it wasn't ratified, if that's the case, because this is a contract between you. And if ratification is necessary to that degree, then somehow there's no contract. You can't, in other words, you can't, okay, there's no contract now. I want that provision, but I want this one. I want that one. You address that? How can you, sound like you're having your, trying to have your cake and eat it too?
Your Honor, we are absolutely running that risk. We believe that the court failed to endorse and accept the plea agreement. We believe that as a result, you are empowered then to examine the procedural and substantive reasonableness of the sentence. And towards those 2 points, if I may, sir, I would just say,
well, why should we examine something that's an illegal plea? No, we go back and say your client can then exercise the rights to plead not guilty, have witness come before them, and do all of those things. Why would we do that?
well,
Why do we take that? Why would we do that? Why would we cherry pick your contract? If you prevail, then you have no contract. There's no plea agreement. That's between you and the government. I mean, that's a little judicial activism in it. We're going to say, the district court failed to ratify it. Therefore, we're going to let you decide what provisions of the contract that doesn't exist now would be enforced. That seems to be inconsistent.
Well, Your Honor, we just believe that the issue before this court right now is the waiver effective? And it's effective if the district court accepted it, but it didn't. And as a result, the waiver is
I have one
ineffective.
question. I understand. You understand? Are you saying on the record you don't mind risking that your client would go back with no plea agreement, and you just go back to pleading guilty or not guilty at his choice? Is that right?
Yeah, that's the risk we run because we believe a substantively and procedurally reasonable sentence would be a better outcome for him.
Well, but to follow up on what
All right.
Judge Gregory said, you leave yourself open for getting a much bigger sentence that the district court would conclude is appropriate and we would affirm. So, I mean, looking at sort of all of the risks here, you still are pursuing this argument, right?
Your Honor, he's serving about 12 and a half years. He did not manufacture. I'm not terribly concerned about worst case scenarios. I would love for a district court to give us the honor of more fully explaining his response to the significant rehabilitation efforts of this defendant. That was the central thesis of his sentencing argument, and not responding to the central thesis is what this court held in 2020 in the United States versus Lewis that required.
Counsel, I'm sorry, I'm just having a little trouble hearing you. Did you say that? Did you say that his exceptional rehabilitation and recovery was the central thrust of his argument? And then what did you say after that?
Yes, Your Honor. It's the central thesis because I've taken that from this court's opinion, and I can see you don't hear me that well, so I'll get closer. Is that helping?
Yes, thank you.
This court held in 2020 in the United States versus Lewis that where a district court failed to respond to the central thesis of a defense mitigation argument, it needed to be vacated. And
can I ask you a question? Sorry, I just want to stop you there and ask for clarification. So that is also how I read both the district court transcript and your brief, that the thrust of this mitigation argument was about the conceitedly very exceptional rehabilitation and recovery efforts. Was there a separate argument made either before the district court or in your brief on appeal that put to one side the recovery and the rehabilitation, just the argument that Judge Gregory was outlining, put that to one side? This is the product of a mental issue and a compulsion, and the sentence ought to reflect that as well. Because I don't see that as a separate argument before the district court. But if there is somewhere where it exists, I would like to know.
We would suggest that's implicit in the rehabilitation efforts that he made. The court referred to it as him being sober. And that, I guess, is an appropriate term. It's not an adequate response, we would suggest, to the extent of rehabilitation he had undergone.
I gotcha. So it's sort of implicit, he needed the rehabilitation and the recovery because there was a problem.
Yes, Your Honor. And finally, if I may, I'll close. We would just point out that pre-sentence court is statutorily mandated any felony. It happens by operation of law, whether there's a plea agreement or not. So the court's reference to the PSR calculations is something that must happen because they have to determine the advisory guideline range. But it's not necessarily, or by any stretch of the imagination, evidence that the court has accepted the plea agreement. And with that, thank you very much, and we would close.
Thank you so much, Mr. Howard, Ms. Fritz. We appreciate your arguments. We're sorry we can't come down and greet you personally, but nonetheless, we're very appreciative of your fine work and your efforts. Thank you for your arguments. Be safe and stay well. Thank you.
Thank you, Your Honor.
Mr. Greenberg?
Your Honor, here's, oh, there we go, my video. Sorry about that. Pardon me. May it please the court. I will focus on the Franks claims, as our briefs have done. Allowing the result below to stand would tell line-level federal officers they can violate core Fourth Amendment rights with impunity, so long as they first trick a magistrate into issuing a warrant. The Franks claims here involve the same problem Bivens itself addressed. Rogue, line-level federal law enforcement officers violating Fourth Amendment rights during standard operations in United States territory. The decision below would enable such officers to nullify Abbasi's mandate to preserve Bivens' claims in common law enforcement contexts simply by illegally obtaining a warrant before committing the same types of violations as in Bivens. That contradicts existing precedents, as this court's recent decision in Hicks shows. Hicks provides,
Hi.
Yes, Your Honor.
Can I just ask a quick question? So sorry, I needed a second to get oriented, but I think you started by saying that you wanted to focus on the Franks claim, is that right?
Yes, Your Honor.
Okay, so the district court, in doing the Bivens analysis, sort of focused on the overall claim at issue, this sort of wide-ranging conspiracy that involves investigators and prosecutors, starts at the search warrant application and goes all the way through to post-trial proceedings, and said, when I look at this thing as a whole, this is a new context and there are special factors counseling hesitation. Is that not the right way to look at this? You think we need to go claim by claim?
Absolutely, Your Honor. It is appropriate to go claim by claim, and the district court erred by conflating multiple claims. It is different claims can arise from totally different contexts, and to conflate claims, for example, the Franks claims are based on the obtaining of a search warrant. Some of the other claims are based on events, years later, and to conflate them all into one big lump and treat one case as a whole, that would be inconsistent with precedent, including, for example, the Sixth Circuit's post-Abbasi decision in Jacobs, which analyzed the claims claim by claim.
Well, I hear you. This is Diana Motz. I hear you. I'm sorry, Judge Harris, did you have a follow-up?
No, please, go. No.
I hear what you're saying, but all the claims have to pass the Bivens argument, or most of them do, and the immunity arguments. So, and those standards for Bivens and standards for the immunity are universal. So I'm not sure I understand why it was incorrect for the district court to follow the procedure it did. I can understand why you disagree with the district court's conclusions with respect to immunity or the Bivens claim, but I don't understand why he would have had to do it claim by claim.
Well, Your Honor, the Franks claims involve only 2 individual line level officers, whereas some of the other claims involve as many as 4 or 5 different law enforcement officials, including prosecutors. Those are
what difference does that make with respect to whether Bivens applies to them or whether they have immunity? You look at each individual person to be sure, but I don't understand why you'd have to go claim by claim. I still don't understand.
Well, I mean, if Your Honor, if the court were not to go claim by claim, and it has, I believe, in cases in the past, such as Eunice, gone claim by claim, which if it didn't go claim by claim, you would have a result that would unfairly deny remedies to someone who was whose Fourth Amendment violates in the heartland of Bivens were violated simply because sometime later in the case, you know, a high-level official got involved and did something wrong. That would be unfair. It wouldn't be fair to deny a remedy simply because, you know, let's say the U.S. Attorney General got involved and you know, what's part of the case. It would be fundamentally unfair to deny a remedy and would be inconsistent with the deterrent purpose of Bivens that Abbasi reaffirmed. It would be inconsistent with Abbasi's mandate to preserve Bivens claims in the Fourth Amendment search and seizure context. Just because there's a due process violation later by a high-level official, that would just be unfair.
But counsel, I totally understand your kind of common sense argument that just because, you know, the wrong is so grievous that it goes all the way up to the U.S. attorney doesn't mean that we should come to a different result. But I'm kind of worried that it does mean we should come to a different result under Abbasi, because, I mean, I think your hypothetical is really good. If these investigators are going to come in and say, oh, you know who else was in on it? The U.S. attorney. I don't see how that doesn't make it a different context for purposes of Bivens.
Well, Your Honor,
there's nothing like that in Bivens. It was just these two guys, kind of on their own, doing misconduct.
Well, Your Honor, in fact, Hicks actually shows that the involvement of a supervisor shouldn't change the analysis. There was a supervisor who arrived in the scene in Hicks. That supervisor let the plaintiff, who was the U.S. Secret Service agent, by the way, a pretty significant difference from all the other cases. Certainly Bivens itself, the plaintiff was actually a law enforcement official and so was waiting for a motorcade on the highway. And it was part of his mission and showed his credentials. The supervisor actually arrived and let the plaintiff leave, and the court did not deem that to be relevant to the to whether there was a new context. It's here in this case, there's no allegation or evidence that any high-level official had anything to do with the Franks violations. We're talking about 2 line-level law enforcement officials. They, defendants Lady and Mosley. You know, this, as Your Honor seems to be suggesting, this, if the U.S. attorney himself were involved, or if the deputy attorney general were involved, that could be certainly a different case. But that's not this case. And you know, we simply have here line-level law enforcement officials, and that's just not meaningfully different from Bivens itself. And to view the case as a
sorry, counsel, can I just assuming we're looking just at the Franks claim, I hear what you're saying, you know, line-level law enforcement officers, but you know, a whole bunch of Fourth Amendment law really does emphasize the getting of a warrant as a distinct phase of the process. And we treat kind of pre-warrant and post-warrant context very, very differently. And so, you know, getting a warrant is like a whole big deal with a whole separate set of rules. And so why isn't that enough to make it a different context? That this involves getting a warrant, which Bivens didn't.
Well, Evans versus Chalmers, although it's not a Bivens case, holds that where law enforcement agents mislead a prosecutor in the course of initiating a prosecution, that's a viable claim. And that's certainly at the heart of the Fourth Amendment common and recurrent standard operations context that Abbasi mandates be preserved. The fact that there are some later events that are unusual or different from core Fourth Amendment situations. I mean, Frank's claims, as this court said in LeBron, I mean, district courts routinely address questions of probable cause. In Humbert, where no Frank's claim was raised in the district court, was raised in the criminal case. I know that's not a Bivens case, but I'm just pointing out the fact that many years later, the plaintiff brought a Frank's claim, and this court upheld the Frank's claim. Now, my point in saying that is that it would be fully consistent with this court's jurisprudence to make a distinction between the events that happened months and years after obtaining the search warrants that destroyed pharmacare and the search warrants. I mean, these are simply different things. The Fourth Circuit this court has not looked at, has not conflated different claims and different types of constitutional violations by different groups of different levels of law enforcement officials the way that the district court did. Now, I do want to quickly point out some of the factual differences in Hicks, and there are more than 10. There's more than 10 ways that the facts in Hicks differ from Bivens itself in ways that are no less significant and the supposedly meaningful differences the district court identified for the Frank's claims here. These differences include: one, the plaintiff, as I mentioned earlier, was a U.S. Secret Service agent during the events at issue. Two, the two defendants, Ferreira and Phillips, were officers of the U.S. Park Police. That's an agency that was not involved in Bivens or any other previous Bivens case. Third, Hicks was stopped twice, each time by a different officer. Fourth, Hicks was allowed to leave in between the two stops. Fifth, when the first stop occurred.
Counsel, I'm sorry. Well, actually, I was about to say I remember Hicks really well, but so I remember Hicks very well. But bottom line, Hicks was two low-level law enforcement officers conducting a warrantless search and seizure. Exactly what happened in Bivens. This is about investigative officers doing this complicated sort of data analysis, running reports, construing them, figuring out what's probable cause, what isn't, going to a magistrate, getting a warrant. I think you have to address why that isn't enough to make this at least a different context. And then I guess I would invite you to address also, even if it's a different context, maybe you want to argue there aren't special factors counseling hesitation. If it's a different context, that's not the end of the inquiry for you.
Correct, Your Honor, absolutely, and thank you. Now, with respect to your first question, the Supreme Court's decision in Grow, which is cited in our papers, that involves a Bivens claim based on a defective search warrant. And in that case, the Supreme Court held there's a Fourth Amendment violation where an ATF agent prepared and signed an application for a search warrant and led a team of law enforcement officers, including both federal agents and members of the local sheriff's department, in executing the warrant. And the court held that qualified immunity from the Bivens claim did not apply, and that the warrant violated the Fourth Amendment. So the presence of a warrant is not a basis under Supreme Court precedent for distinguishing this case from Bivens itself. And I would point out that in Hicks, this court recognized that pre-Abbasi cases recognizing Bivens claims, even without conducting the Abbasi test, remain good law. For example, it cited this court's 2006 decision in Schwartz and a DC Circuit decision by then future Justice Ginsburg in 1987 to support its conclusion. With respect to the special factors, and that is a standalone basis for reversing, as Your Honor suggested. The special factors analysis by the district court here was erroneous in a number of ways that require reversal. Most notably, the causation inquiry was completely off, respectfully, with all respect. There's no kind of deep dive causation inquiry required for looking at a Frank's claim. As this court said in LeBron, as I mentioned earlier, district courts consider questions of probable cause all the time, and Frank's claims are routinely addressed in civil cases and criminal cases. Now, the alternative remedies analysis was really kind of the thrust of the district court's opinion, and there it really just followed FARA, which applies an analytical framework like its companion recent case in Ahmed that is fundamentally inconsistent with both Abbasi and this court's decision in Hicks. The remedies analysis under Abbasi preserves pre-existing cases that it cites with approval that make clear there has to be an adequate remedy. May I just, well, I can address the rest later if I'm running out of time.
Yeah, you
Okay.
may finish it.
Okay. Well, I just want to point out real quick, Your Honors, in this case, none of the remedies the order cites creates, not the Hyde Amendment, not the wrongful conviction statutes that FARA cites. They don't create any process for remedying the protecting the interest of Mr. Anaparetti and Pharmacare in obtaining compensation for the destruction of his business. Not only nor did the dismissal of the criminal indictment do anything to protect that interest. Only the Franks claims under Bivens can allow Pharmacare and Mr. Anaparetti to obtain a remedy against defendants Slading and Mosley for causing that injury. And as Chief Justice Rehnquist wrote in Malesko, when a plaintiff lacked any alternative remedy, that's a situation where the court has extended Bivens. And that's a situation with the Franks claims here. It's damages or nothing. And with respect to the FCCA part of the district court's analysis, very quickly, Your Honors, that just Abbasi leaves intact Carlson, which, like Hui, holds that the FTCA and Bivens are parallel and complementary remedies. The district court violated Agostini's mandate that the Supreme Court has the prerogative to overrule its own decisions in deciding that it can consider the FTCA claim as a separate remedy. Thank you.
Thank you, Mr. Greenberg. Klepper?
Yes. May it please the court. The plaintiff is asking to hold my client, Ms. Pascal, a prosecutor, liable for failing to preserve evidence, allegedly for the express purpose of undermining his defense in an ongoing prosecution. And merely by stating plaintiff's thesis, this establishes this case falls within the heartland of absolute prosecutorial immunity. And what the plaintiff does is try to spin his way out by saying that this particular act of failing to preserve evidence, document destruction, is always administrative no matter the context. And we know that any argument that depends on such a bright line distinction that a certain act is always administrative, regardless of context, is wrong under Van de Kamp versus Goldstein.
Can I ask you, counsel?
Yes.
In what way was your client involved in the investigation prior to the fall of 2013?
There is an allegation about my client being involved with the Maryland Attorney General's office. It is a single sentence, but that's not part of the complaint in terms of what the activity was or what my client's involvement was.
It's not part of the complaint, but there's an allegation about it?
There is a background allegation that before my client became a special AUSA on this, that she had been involved at the investigative stage with the Office of the Attorney General of Maryland.
But isn't that pretty important with respect to the claims against her? I don't understand.
It is not important with respect to the particular claims that are alleged against her, Your Honor. The particular claim being alleged is that she participated in the destruction of documents. And under Van de Kamp, Your Honor, we ask three questions. The first is, does the act post-date the probable cause determination? Second, does it relate to the specific prosecution of the tort plaintiff? And third, does it involve the attorney's legal knowledge and exercise of related discretion? And the answer to all three is yes, and that is why immunity attaches. And actually, to answer your question a little bit more, Judge Motz, the case of Nero versus Mosby definitively settles that, because in Nero versus Mosby, Ms. Mosby went on camera and said that she personally had been involved in the investigation. and that was undisputed. But the act that she was accused of, the particular acts giving rise to liability, according to the complaint, those were in her capacity as a prosecutor. And what this court further held in footnote 4 of Nero versus Mosby was that a generalized allegation of impropriety during the investigative stage, but without particularly alleging an act that would give rise to liability, was not enough to overcome.
Well, was your client personally involved in handling post-trial motions?
I am not sure of the answer to that, Your Honor. What I do know is, and I apologize if perhaps I should know the particular answer. I mean, she was the special assistant U.S. attorney working with
Ms. Wilkinson.
Ms. Wilkinson during that time. So I will say, yes, she's involved in that sense. I mean, she is signing the pleadings. But
At the time when the decision was made to destroy the evidence,
yes,
was she involved then?
yes, she absolutely was involved in the ongoing defense and the post-trial motions. And there's no dispute about that, Your Honor.
Can I ask you a question, Mr. Klepp?
Yes.
Just about, just while we're talking about the complaint and the allegations, I know you're right now talking about destruction of evidence, but is there also a claim as to fabrication of evidence before us? And is there also, do we also have a fabrication claim?
There is not a fabrication claim, Your Honor, for the reasons, well, let me say this. The district court said there was a fabrication claim that was incorporated into the Maryland state law counts and said that those could proceed. Now, this all goes to footnote 4 of Nero versus Mosby, which in that case, there were some conclusory allegations of impropriety. Here we have something that's even further away from the pleading standards, because what the plaintiff said in counts 19 and 20 that the district court held were reverse incorporated into the earlier state law counts. What those said was expressly, we have no reason to believe that Ms. Pascal and Ms. Wilkinson were involved in the fabrication of evidence. But if discovery should show something different, then we make these alternative claims. So this is a contingent claim that is expressly speculative on what may or may not emerge in discovery, and of course cannot survive the Iqbal pleading standard. And
I'm sorry, so you don't think there's a claim floating around somewhere that even the complaint says they didn't know anything about this before the indictment, right? That's what the complaint says.
Yeah.
But that there still remains a post-indictment claim for fabrication of evidence, which I understand you think would be subject to complete and absolute immunity under Buckley. But is there a claim floating around here that post-indictment for the retrial fabricated evidence?
I don't believe there's such a claim, Your Honor. And if not, certainly, our main issue that we have on this point is that the plaintiff expressly says at some point in time, maybe something happened. And that is not enough. We have not been given the fair warning of what the allegations are. There was discussion during the first argument this morning about remedies. There was a lot of discussion about remedies, and I think—
Counsel, I'm sorry, before you go on, can I ask you, were any of Ms. Pascal's actions the basis for counts 15, 16, and 17?
What about 15? So what those counts did was they expressly were stating side-by-side state liability as an alternative to the federal liability. Mm-hmm. And so they rested on the same allegations as the district court held that, and I don't think there's dispute that those state law counts incorporated the allegations of document destruction. And then it wasn't clear whether they then incorporated the subsequent counts that had this set of expressly alternative facts, that hypothetical facts. And so there was no standalone liability, no standalone facts that were alleged. It was merely a different cause of action. And they were inextricably intertwined in the same way as in Nero versus Mosby. This court took all causes of action arising out of a particular factual nucleus and examined them together. This was not a claim-by-claim analysis. I would like to make a point about remedies that came up a lot during the first argument today, and I think that all lawyers have become experts in remedies since November, if you're simply following the legal news. When the courts say that absolute prosecutorial immunity applies, they are not saying the plaintiff has no remedy. All they are saying is that the remedy is a motion in the criminal case. And that is the Pennate case from the First Circuit that plaintiff relies on, and the Singleton case from the Fifth Circuit that plaintiff relies on. Those are all cases where the courts noted there was no remedy in the criminal case for this action. And here that remedy was applied. There was the sanction. And I can also say that, I'm one of the things that I learned in the course of handling this appeal is in Imbler, it's not just talking about we don't want to chill prosecutors' actions. We also think that absolute prosecutorial immunity benefits defendants because the courts do not want a judge in Judge Russell's position here to worry, even subconsciously, about the prosecutors facing civil liability, because there is a fear that that unconscious knowledge could affect the truth-seeking function on the motion for sanctions. And I'm a lawyer who does a lot of appeals and post-conviction work on the criminal side, federal and state. And it is hard enough getting relief on a motion for sanctions or post-conviction motion as it is. And I can absolutely say that what nobody wants on this is to make it even harder. If there is something that might cause a judge subconsciously to back away from a finding that relief is available. Because as hard as it is to get relief, getting relief on appeal is even harder. And
Counsel, I'm sorry to interrupt you again.
Oh, absolutely, Judge Moss.
But I am as interested in your client, and you would agree with me to the extent that a fabrication was investigative, she has no immunity.
If the conclusion were investigative in the traditional sense, now we don't know the facts that she has alleged as to my client, there may be a set of facts. Now, what my counsel for the co-defendants
you haven't conceded anything. I just want to.
I have not conceded, but what I'm saying is that the particular. I'm sorry, Your Honor.
I just wanted to say, then, going back to count 19.
Yes.
It pleads in the alternative that she engaged in one or more overt acts in furtherance of the conspiracy, deliberately fabricating materially false evidence. Now, count 19 is a Bivens claim, but that's the factual basis that's put forward for it. It was dismissed. But is it possible that the allegations of fabrication under this claim could support the state law claims in count 15?
No, Your Honor. And I'm sorry, they could support under the plaintiff's theory. He could have been pleading that. But in that regard, what I would do is I would incorporate the arguments that the Lading defendants are making here, which is that the particular act of fabrication that was alleged in the complaint was putting together summaries for presentation to the grand jury. And as those defendants have said, and I think argued correctly, that would still be a post-probable cause determination at that point. And so if there were an allegation that my client were involved in it, because it would have to relate to some fact in the complaint, in that alternative world, Your Honor, had the plaintiff properly pleaded that, there would still be immunity on those facts for the reasons that Lading argues.
So what you're saying to me is, no, this doesn't work because the state law claim couldn't have been the basis for this. Is that what you're saying?
I believe what I'm saying is that the state law claim doesn't have any independent facts. And the only facts it could draw would be from elsewhere in the complaint. And counts 19 and 20 don't have any facts.
No, but 15 does. But what you're saying is I just can't roam around looking for a basis for the claims in 19 and 20. Is that right?
Certainly nothing that is alleged in the complaint as to any of the defendants, Your Honor, would be something that would fall outside absolute prosecutorial immunity on these facts. for the reasons that the lading defendants argue. If my client was a party to the lading allegations, then in that circumstance, their absolute prosecutorial immunity would apply for the reasons that those defendants are arguing, Your Honor. All right. If no further questions, I'm over my time.
Thank you, Mr. Kepler. Mr. Frey?
Yes, Your Honor. May it please the court, good morning. My name is Brian Fry and I represent Sandra Wilkinson. And I'll be speaking as to the non-Franks defendants and counts 11 and 13, the Fifth Amendment claims. Your Honor,
I'm sorry, so this is on Bivens? I'm sorry, these are claims that were dismissed under Bivens? I'm just trying to get situated.
That's correct, Your Honor.
Thank you.
As to the non-Franks defendants, as we argued in our brief, it's our view that the claims against Ms. Wilkinson, Mr. Capabianco, and Mr. Ryan have effectively been waived on appeal because they were not meaningfully pursued in the opening brief. And Mr. Greenberg effectively confirmed this fact this morning. I think the first thing he said was that he'll focus on the Franks claims as our briefs have done. There are simply no substantive allegations as to the non-Franks defendants in the opening brief, and under this court's precedent, those claims should be deemed waived. Mr. Anaparetti's attempts to briefly resuscitate them in reply was simply too late. That being said, Your Honors, to the extent that Your Honors are interested in hearing as to the non-Franks defendants, and I presume as to the Franks defendants as well as to claims 11 and 13 involving purported fabrication of evidence in count 11 and destruction of documents in count 13, I'm certainly happy to speak to those on the substance of the extension of Bivens analysis. As Your Honors are clearly aware, in the underlying briefing and the underlying arguments in this case, counsel for Mr. Anaparetti cast a story about a grand overarching conspiracy, which purportedly involved all of the defendants in this case working in concert to falsify search warrants and evidence and to destroy documents critical to Mr. Anaparetti's defense. And as is not a surprise, as a result, the court's opinion below focused on an analysis consistent with the way that the case had been argued below. On appeal, Mr. Anaparetti's counsel has attempted to shift the case, has expressly dropped counts 9 and 19, 19 being the conspiracy count that was recently discussed, and has instead chosen to focus on the Franks defendants in an apparent recognition of some of the challenges that the arguments below face and were highlighted in the court's well-reasoned decision dismissing many of the counts against the defendants. So, Your Honors, we submit that in the context of counts 11 and 13, the court, should it choose to engage in an Abbasi analysis, and again, we think that that's not necessary given the waiver issue, we think that this is clearly a new context. Abbasi declared and Hernandez confirmed that any meaningful difference, even if small, between a given claim and an acknowledged Bivens claim is sufficient to find a new context. And here, as to counts 11 and 13, the differences are certainly far from small. Existing Bivens precedent has never recognized a cause of action based on a violation of substantive due process under the Fifth Amendment. And Your Honors, we submit that that fact alone is sufficient to find a new context in this case. We also note that the differences in roles among the various defendants named in counts 11 and 13 are meaningful. As to Ms. Wilkinson, for example, she's a federal prosecutor, and there's no existing Bivens precedent recognizing a cause of action against a federal prosecutor, and certainly not for alleged destruction of documents. As to Mr. Capabianco, Bivens precedent, again, has not recognized an action against someone in his position. He was an in-house investigator at the U.S. Attorney's Office, and there's certainly been no cause of action recognized for someone who did something so minimal as conducting data analysis and supporting a prosecution. And as to Mr. Ryan, the alleged conduct involving purported fabrication of evidence and destruction of documents, likewise present an entirely new factual context. Simply put, we submit that there is no real argument in this case that this is a new context, and therefore the court must consider a special factors analysis. Turning to that analysis, as your honors know, per Abbasi, a special factor is one which causes the court to hesitate in finding that the judiciary is well suited to consider and weigh the costs and benefits of allowing damages actions to proceed. And it's not a question of whether a remedy should exist, it's who should decide, and the Supreme Court is instructed that the answer will most often be Congress. As your honors are well aware, this court has declined to extend Bivens repeatedly in the post-Abbasi context, and as cited in our briefs, federal circuits around the country have similarly resoundingly declined to extend Bivens post-Abbasi. And I'll submit, your honors.
Let me just ask you a question about the special factors. Assuming for a minute that we could isolate the Franks claim and say, look, we need to go claim by claim by claim. If there's a prosecutor, it's out. If it's the Fifth Amendment, it's out. But look, here's one that's just Fourth Amendment, line level police officers. We're only going to look at this one. So what are the special factors counseling hesitation on the Franks claim? Because as your colleague says, we do those all the time under 1983. And it doesn't involve any, it hasn't been disruptive as far as we know, that we have to probe into the magistrate's mind, figure out what's material, what's not material, whether there was deliberate or reckless falsehood. What's so disruptive? What's the special factor that would prevent us from doing that on the federal side?
And your honor, forgive me, at the outset, I should have noted that Ms. Buckman will be speaking to the Franks defendant claims, and I'm certainly
Sorry. I'm sorry. I don't understand the division of labor here. I have the sheet, and yet I can't keep it straight. Sorry, go on.
No,
I'll ask Ms. Buckman. It's fine.
She'll be speaking to those claims, and Mr. Wintermeyer will be speaking to the immunity claims.
Okay.
And frankly, your honors, I've exceeded my allotted time at this point, and I'm happy to pass the argument along to Ms. Buckman, who can address Judge Harris's question more directly.
Thank you, Mr. Freed. Ms. Buckman?
May it please the court, Jody Buckman, counsel to Special Agent Mara Lading. I'll be addressing the Bivens claims against Agent Lading and Agent Mosley relating to the warrant affidavit, the so-called Franks claims. Mr. Anapredi's main argument is that Bivens claims alleging Fourth Amendment violations by line-level federal agents are per se valid, and the court does not have to conduct the Abbasi test. In support of this argument, Anapredi cites a few Bivens cases that did not conduct the Bivens analysis and makes the sweeping conclusion that in so doing, these courts recognize the validity of the Bivens claims. That is not what these cases hold or conclude. The cases either predate Abbasi, argument was not raised by the defendant in the case, or the court dismissed on immunity grounds. We don't believe that's a reasonable inference from the holdings of the cases. We believe that Abbasi and this progeny require the court to conduct the Abbasi analysis. And I would refer the court to a recent Eighth Circuit case from December of 2020 called Ahmed versus Weicker. You may recognize the name Weicker. It's also the defendant in the Farah case. The case came out of the Eighth Circuit. The plaintiffs alleged that an investigator violated their Fourth Amendment rights by providing false information and submitting a false affidavit, leading to their arrest. The court held it was required to conduct the Abbasi analysis, even though the case involved a Fourth Amendment violation by a federal agent. Turning to the Abbasi test, there are at least 5 meaningful differences between Bivens and the Franks claims, each one of which is sufficient to present a new context. First, this was not a warrantless search and seizure of a private citizen. Here, search warrants were issued for corporate property owned by Pharmacare's legal entity at multiple locations. And these warrants were issued based on an affidavit, which was the culmination of a year-plus investigation by a state and federal healthcare task force. The Weicker case that I just referenced, Your Honors, there's a quote from it that says, "Lying and manipulation, however bad they may be, are simply not the same as the physical invasions that were at the heart of Bivens." We would submit this is the same situation here as it was in that Weicker case and as it was in the Farah case out of the Eighth Circuit, the Cantu case out of the Fifth Circuit, and the Karkalis case out of Pennsylvania, where investigatory and case-building activities presented a new context. The second meaningful difference is that the 5 Bivens appellees are from 4 different agencies. unlike the agents in Bivens. And I recognize for the Frank-based claims, this is Mara Lading and Robert Mosley, but Lading and Mosley were from different agencies. And in the Cantu versus Moody case out of the Fifth Circuit, the court held that a claim involving different conduct by different officers from a different agency presented a new context. Third, proving these claims would require the application of a different legal mandate than Bivens. And this is one of the factors listed in Abbasi for creating a new context. For a false warrant affidavit claim, the proof would require the plaintiff to establish that the statements were false, they were made knowingly and intentionally or with reckless disregard for the truth, and that without them, there would be no probable cause. And this is a quote from the recent case of Ahmed versus Weicker. Bivens did not require this type of fact-checking and conscious probing, which can, as the Supreme Court has warned, impose substantial costs. The fourth way this case is that Mr. Annaparetti seeks damages for warrants executed on corporate entities to search for corporate properties. Mr. Annaparetti himself was not searched. Mr. Annaparetti himself was not seized. Mr. Annaparetti was in Las Vegas when the searches occurred. Mr. Annaparetti tries to get around this problem with the doctrine of ratification to allow the pharmacare entities which were not pled as part of the complaint to be pled. Whether this applies as not, Your Honors, it certainly presents a meaningful difference for Bivens. It also raises the question of whether a corporate entity can assert a Bivens claim. I would point, Your Honors, to a case cited in our brief called Lifesavers Concept, where a corporate entity asserting a Bivens claim on behalf of employees presented a new context. We believe at a minimum, a corporate entity asserting a Bivens claim, if the doctrine of ratification is allowed, is a meaningful difference for Bivens. Fifth, and finally, Lading and Mosley were not the proximate cause of Annaparetti's alleged injuries. The district court correctly looked to FARA on this point. There were numerous intervening acts between the warrant affidavit and Mr. Annaparetti's alleged injury. I will now turn to the second part of the test, the special factor. The district court did not err in concluding that special factors counsel hesitation in extending Bivens to the new context present in this case. First, the claims pose risk of intrusion into the executive branch authority to enforce the law and prosecute crimes.
Okay, can I stop you there? Because that's sort of where my question was. Why is that especially disruptive? Why does that counsel hesitation under Bivens when it doesn't under Section 1983? We do it all the time. We inquire into the magistrate with the attendant risk to interference with the law enforcement efforts of state law officers all the time. So why is it especially problematic if we do it with federal officers as well? Seems like we'd just be doing the same exact thing.
I would submit, Your Honor, it's different in that there was no Frank's claim raised during the criminal part of this case.
Yeah, I don't know. Why does that matter?
Well,
so just because it would be harder for us to do it because we'd have to go back a couple of years?
Yeah, I mean, more than 70 years. But yes, Your Honor, it is a special factor noted in Bivens, noted by the district court. And we believe...
So I'm sorry, I just want to make sure I understand. So your answer would be we could write an opinion saying in this case, special factors counsel hesitation in a way they would not had the Frank's claim been raised below during the original criminal prosecution.
I think that's a distinct difference. I also would point the court to that Ahmed versus Weicker case that with regard to the level of expense that's involved in looking at affidavits some years later. We also believe there are alternate remedial structures that were potentially available to Mr. Annaparetti, as noted by the district court and by the Eighth Circuit in both FARA and the Ahmed case. There is the Hyde Amendment, the 28 U.S.C. 2225, the Federal Tort Claims Act claims, and we cited cases in our brief where courts have found that the Federal Tort Claims Act claims were special factors, did fit within that analysis. And also the court...
Sorry, counsel, because I really am bearing down on this one. I understand, and I read FARA, I understand sort of the argument that, look, just the mere fact that this particular plaintiff might not be able to get relief under any of those alternative remedial structures isn't dispositive. But isn't there an argument that there's something more going on here, that like none of those remedial structures really has anything to do with this stage of the, you know, the Hyde one and the other, the second one you said, they're not really about this stage of the criminal prosecution. They're about you're prosecuted impermissibly, you're exonerated later. This is just about getting a search warrant. And I mean, the Federal Tort Claims Act, I understand, but there's just, has there ever been a case suggesting that this would not come, that the officers would not be immune under the FTCA for swearing out a search warrant affidavit just as a discretionary function? I mean, it seems like the FTCA really has nothing to say about this either.
No, I mean, I did not find that, Your Honor, but I would say that
I didn't hear what you said. What did you say in response to?
That I did not look into that specific issue, Your Honor, but courts have recognized that Federal Tort Claims Act claims do present a special factor. And
well, if they're at least theoretically available, but what if they're not?
Well, then, Your Honor, I would point you to the Farrah case, which says that the fact that these remedies may not directly apply or do not allegedly sufficiently compensate Mr. Anaparetti for his injuries does not change the analysis. And what courts have said—
That's where I started, but I understand them to be saying, look, the fact that your individual person may not be eligible for relief doesn't matter if we can infer from the remedial structure that Congress had this in mind and chose not to cover it. But I'm saying, I look at this remedial structure and I don't see how I can infer from this that Congress was even thinking about officers swearing out an unlawful Frank's affidavit and decided not to cover it. It looks to me like they weren't even in the same general area as that example. That's my concern.
I understand, Your Honor. And the only other thing I would say is that the remedy for the alleged falsities in the warrant affidavit under the current structure in federal jurisprudence was a Frank's hearing during the criminal case, not a Monday morning quarterback analysis 8 years later.
Isn't his claim that he didn't know they were lying in the Frank's affidavit because everyone was busy fabricating evidence and destroying documents, so he didn't find out until later? What was he supposed to do?
He claimed that he did not learn that the medic analysis, which was just a small part of the warrant affidavit, he did not know about that until 2015. However, if you look at the actual allegations in the case and our brief, we listed at least 13 items in that warrant affidavit that the owner, CFO, former CEO, founder of the company would clearly have been on notice of at the time of Frank's hearing would have been appropriate to raise in the criminal case. And I would leave Your Honors, I know I've gone over time, with the fact that, you know, if Congress had intended a remedy for this type of situation, then we believe Congress would have had one. And I would defer to Wes Wintermeyer, who's now going to address the issue of immunity.
Thank you, Mr. Wintermeyer.
May it please the court. I'm Wes Wintermeyer. I represent Special Agent Robert Mosley. I'm speaking for him and the 4 other dismissed Bivens defendants. I'm going to address the immunity issues. I, of course, want to address the immunity of that Frank's claim, and given time, I will address the immunity issues with respect to the other claims as well. Speaking about Frank's and the alleged fabrication of evidence before Mr. Anaparetti's trial, absolute immunity fields the activities of Agents Lading, Mosley, Capobianco, and Ryan, because they're alleged to fabricate evidence in one form or another before the trial. Under Imbler, we don't look at labels. You don't have to have the title prosecutor to be entitled to absolute immunity. To the personal nature.
Counsel, you keep going in and out. Excuse me, keep going in and out.
Very simple. I'll get a little closer. We, of course, look to the functional nature of the activities involved. The Supreme Court's decision in Buckley versus Fitzsimmons is very instructive. It says that after the decision to seek an indictment had been made, that the activities taken around or after that are much more likely to be related to the prosecutorial effort. Timing doesn't control there, but it is likely relevant. The decision to seek an indictment is made. These descriptions fit the actions of the agent here. Judge Motz, you previously asked the proper question, if these activities were investigated, there would be no immunity. But under the facts here, these actions were not purely investigated. Mr. Anaparetti alleges that his investigation began in May 2012. And the search warrant and the grand jury, its indictment here, were issued over 1 year later, July 2013. It was well beyond the investigation into the decision that probable cause exists and that an indictment should be reached, that Agents Lading and Mosley prepared their affidavit, presented that to the magistrate on the morning of July 23rd, 2013, and then later presented it to the grand jury that returned the indictment later that same day. It was not until the 24th that an arrest warrant was issued, and then the 25th when the searches were executed. Under those circumstances, their activities, viewed as the common nucleus of fact in which they were alleged, those were prosecutorial activities to secure an indictment under which Mr. Anaparetti was eventually prosecuted. Adding agents Capobianco and Ryan into the picture, their activities fit into the same circumstance. They're alleged to have only taken actions after the return of the original indictment. Agent Capobianco was alleged to have sent an email in February 2014 requesting the preparation of certain calculations that were, the plaintiff alleges, presented to a grand jury to return the superseding indictment. Similarly with Ryan, he put together a spreadsheet that was used to return the superseding indictment. The allegations there necessarily tied those agents' activities to the return of indictments by the grand jury. And precedent holds this type of activity is prosecutorial and therefore entitled to absolute immunity. We also addressed why qualified immunity would be applicable to these pretrial activities for various factors. I'd like to turn to the post-trial disposal of documents at the basis of count 13 against Prosecutor Wilkinson and agents Mosley and Ryan. Mr. Klepper previously explained why absolute prosecutorial immunity applies to that decision by Wilkinson to dispose of certain unused documents that she determined would not be used in the new trial. But the court could affirm for the alternative reason qualified immunity applies, because agents Wilkinson, Mosley's, and Ryan's action after trial did not cause Mr. Anaparetti a constitutional violation for these circumstances. It's undisputed that his counsel, his trial counsel, had access to the documents before and during his 5-week trial. It was only after his conviction, several months after his conviction, that a decision was made that those unused documents were no longer needed to be disposed. Judge Anderson, the district court judge below, he correctly reasoned that proximate cause was missing, and he actually dismissed one count of the complaint against the different defendant for that reason. But this same reasoning extends to the Bivens defendants. Count 13 can be dismissed for that alternative reason. With that, I thank the court for this time, and we ask you to dismiss the Bivens claims.
Thank you, Mr. Wintermeyer.
Your Honor, may I be heard just briefly on an administrative matter? This is Brian Fry from Ms. Wilkinson.
Is it to clear up something in the record? What do you mean?
No, Your Honor, purely administrative. I just wish to note for the court that counsel for Mr. Capobianco and Mr. Ryan are on the line and available for a question should the court have any. They are not on video because of the time constraints with oral argument, but wanted to make clear that they are available to the court.
Thank you. Thank you so much.
Thank you, Your Honor.
Greenberg?
You're on mute.
My apologies. I didn't realize I was muted. Your Honors, I have five points in rebuttal with respect to the Franks claims, further addressing Your Honor's questions about those claims. Number one, there is no allegation of a grand conspiracy. The Franks claims are based on, first of all, we have the notion that our whole complaint is based on a grand conspiracy is inaccurate. The Franks claims make up the bulk of the complaint, and they're not based on a grand conspiracy. They're based on defendants Lading and Mosley recklessly or intentionally submitting a materially false warrant affidavit. Those are discrete facts. The Franks claims are based on a completely different set of events than the other claims.
Counsel, why didn't you bring a Franks claim at the time of the criminal proceedings when the affidavit was filed?
So, Your Honor, first of all, the information essential to bring the Franks claim was suppressed by the United States government in violation of.
Okay, that's what I thought. So how is this separate from those other claims? I mean, your entire Franks claim, the whole reason you didn't bring it is because allegedly there was a grand conspiracy to suppress the evidence that would have allowed you to bring the Franks claim.
Respectfully, Your Honor, the evidence that should have been disclosed under Brady, and that was essential with respect to the duplicate claims issue in Medic 1495. The fact that was improperly suppressed should not be held against Mr. Anaparetti. And moreover, this is a case really more like Humbert, where the case ended before the Franks claim was litigated. In that case, also the government abandoned the case and it was favorably terminated before there was the motions deadline for Franks claims post-dated Judge Russell's dismissal of ruling on September 1st, 2016. There would have been a Franks motion. So that should not be, Mr. Anaparetti and PharmaCare should not be penalized for that. It would be fundamentally unfair, frankly, to hold it against Mr. Anaparetti and PharmaCare that the government suppressed the information needed to bring the Franks claims. That would create an incentive for the government to suppress information in other cases that would deny criminal defendants the opportunity to bring Franks motions, as well as potential, let alone in other situations. Under Lull, this court's decision in Lull, nothing that happened after the lading affidavit was submitted, as defendants say in their brief, defendant Mosley participated in preparing it and providing information for it, and after defendant Laning submitting it, nothing that happened afterward is relevant in terms of evaluating what they did. Now, the fact that information was suppressed and was obtained later, that's not inconsistent with law at all. And in fact, Humbert actually fully supports that point. So it's really, we're looking at a discrete time frame. We're looking at, right around, essentially, the short period around July 23rd, 25th, 2013, maybe the weeks leading up to it when the warrant affidavit was prepared. This is not a case that's going to require, if it's limited to the Franks claims, it would not require any kind of, intrusive discovery. This is not a case where, where we would have, if limited to the Franks claims, it would not, it really would impose minimal burdens. With respect to,
I have a question if you don't have anything that you need to say right this minute. Can we just answer two questions about Ms. Pascali for me? First of all, what evidence specifically did she fabricate?
Thank you, Your Honor. I actually had meant to bring that up. So there are specific allegations against defendant Pascal for fabricating evidence. And by the way, the counsel's argument that the fact that it happened after the charges were brought, that is inconsistent with the Supreme Court's decision in Buckley, footnote 5, and the recent decision by the Third Circuit in Fogel. Now,
counsel.
I'm getting to your question.
But let me just, I know you have so much to get to clarify. So I am taking from what you just said that the evidence you're about to point to is post-indictment evidence. Allegations of post-indictment fabrication, which you think.
Correct.
Okay.
And just to be very clear, this is a different series of events involving different actors in different periods of time than the Franks claims. Totally different. There's no, again, and so here, the relevant allegations, these are discussed more fully on pages 6 and 7 of our response brief. But in short, as defendant Wilkinson told Judge Russell on behalf of her and defendant Pascal, I don't know that the investigation will ever stop, Your Honor. Later adding, I will never stop investigating. That's in JA 155, paragraph 169. During the summer of 2014, they were continuing the investigation. That's JA 157, 173. More specifically, on July 16, 2014, Defendant Wilkinson informed defense counsel that she and defendant Pascal had asked their internal auditors to do the analysis / review. That's paragraph 174 of the complaint.
Counsel, I'm sorry. You have a great knack of a good trial lawyer to talk really fast, get a lot of information in. But let me ask you this. So I just want to be sure what you're saying. You're representing to us that the allegations about Pascal fabricating, all of that evidence was post the indictment. That's what you've been talking about right now.
Based on the allegations in the complaint, yes, Your Honor.
Okay. Got it.
Now, to be clear, the complaint goes on to say that the draft summary exhibit that was produced by defendant Wilkinson on behalf of herself and defendant Pascal had numbers identical to the false calculations the government later introduced at trial, and that Judge Russell found were the most significant evidence in the case. And that was after they abandoned Medic, because Medic didn't want to do the numbers the way they liked. Medic wanted to change things. They didn't like that. That's alleged in the complaint. And those numbers in the draft that defendants Wilkinson and Pascal orchestrated and were presented at trial, those were materially false, as alleged in the amended complaint. Very quickly, with respect to, well, so I think I've addressed the notion that the fabrication claims against Pascal are contingent on discovery. That's incorrect. Unless your honors have any other questions, I would just sort of rest on what I've said, and really sort of the overarching point is that the Franks claims, discrete period of time, two defendants, and this is very different. Oh, and I actually have one other point that I meant to mention, that Judge Harris, you had asked about treating claims separately as opposed to the whole case. In Abbasi itself, the Supreme Court did that. They analyzed the, I think, so-called detention policy claims separately from the prisoner abuse claims, and they even remanded the latter for a ruling on special factors to show how separately they treated them. I'm not saying that always has to be done, but the Supreme Court did that in Abbasi. So it would certainly be fully consistent with Abbasi to do likewise here. I think I'm over my time, so unless you're on.
Let me just ask you, just to clarify quickly. I understand you're pressing your Franks claim under Bivens. Are you arguing on appeal that the district court erred in dismissing the Bivens claims against the prosecutors, or in dismissing the Bivens claims with respect to Fifth Amendment due process claims? Is that something?
That is absolutely something we argued. We make that clear in our opening brief and our reply. It was counsel for defendant Wilkinson was incorrect in saying that we abandoned those claims. However, we do believe that the Franks claims are a much easier call in reversing than the other claims.
All right, Mr. Wintermeyer.
I think we're done, aren't we?
Yes, sir. I was going to rebut on the cross appeal of the immunity issues. And just on that, just that we've heard that much of the conduct here has occurred post-indictment, for which all the agents involved would have immunity because the decision for probable cause had already been made. On the idea that the allegations here are somehow something different than a grand conspiracy between agents and prosecutors to get a conviction to try Mr. Anperetti and to secure that conviction, I'd refer you to the amended complaint, Joint Appendix 154, paragraph 166, specifically alleges that the prosecutors Wilkinson and Pascal learned after the superseding indictment that the analysis, the loss calculation analysis, and it was flawed, and yet they proceeded to present similar flawed evidence to a jury, get a conviction, and tried to protect that through fighting a new trial and then pursuing an appeal. So the allegations do suggest that this was all one conspiracy between agents and prosecutors, for which we think the actors are entitled to immunity. Thank you.
Thank you so much. Thank all counsel for your great engagement and argument. And regret we can't come down and greet all of you under the circumstances, but please know that our appreciation is nonetheless. Thank you so much for your work. Be safe and stay well. With that, I'll ask the clerk to, I guess, adjourn the court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you, judges. We'll be moving you to the